Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this legal education content, please remember to subscribe. It helps our channel grow. For today's live stream, we are delving back into the issue of personal jurisdiction for you Toddy without a crystal ball fans who just can't get enough personal jurisdiction. In fact, we have personal jurisdiction from the highest authority in the land, the U.S. Supreme Court, who has modified the law on personal jurisdiction. So we're going to get deeper into the weeds on personal jurisdiction today than we ever have so far. So all those people who are feeling a shortage and a deprivation of personal jurisdiction in their lives, I hope this will satisfy you, because this is some real core personal jurisdiction stuff. Super fun. Okay, so let us discuss the issue. And this is going to be a little bit nuanced, so we're going to spend a little time here in the introduction. All right. So when we have personal jurisdiction, that comes in two flavors: general jurisdiction and specific jurisdiction. So you can have general personal jurisdiction or specific personal jurisdiction. What's the difference? Well, general personal jurisdiction means that you can be sued about any subject in that place. So if you're subject to general personal jurisdiction, all the bad things that you do, you can be sued in that place concerning those things, because and this for an individual is at least the place that they're a citizen of. So they're the place that they're legally domiciled, and may include other places, but we don't have to get into that right now. And then we have the concept of specific personal jurisdiction. The courts don't have authority over you in general, but they do have authority over you in specific matters. Well, how would that come up? Well, principally, it is where the bad thing that happened occurred within the jurisdiction, and sometimes some more things on top of that, right? So in criminal law, where does the state have personal jurisdiction over you? It'd be where the crime happened. So that would be obviously where the bad thing occurred. In civil law, right, it would be where the bad thing occurred. Or it would be where the bad thing originated from, or so forth and so on, right? So in the Toddy without a crystal ball lawsuits, we dealt with a part of the personal jurisdiction issue on specific personal jurisdiction related to this idea of sufficient minimum context. The idea was, did without a crystal ball do enough stuff in Washington to bring her before the court? So it wasn't the idea as to whether or not the specific acts occurred in Washington. It was whether or not she had done enough stuff in general to qualify for specific jurisdiction. Because in civil law, not only does the bad thing itself have to occur, but there has to be sufficient minimum context. And that can be because you were in the state at the time. So if you punch someone in the face at the state, that's enough because you were in the state at the time. But of course, that didn't apply in the case of Toddy without a crystal ball because it was remote. And so we had to analyze that element specifically. All right, but today we're not really dealing with sufficient minimum context. We're dealing with a different aspect of personal jurisdiction, which relates to what does it mean for how specific is specific personal jurisdiction, right? Because we talked about general type and specific type. So how specific is the question today. So Ford sold a car. The person who owned the car had a car accident in Montana. The person died. They want to sue Ford for product liability. You designed a defective car. I want to sue you. All right. So we at this stage, again, are only trying to answer the personal jurisdiction question. So if you thought the Toddy without a crystal ball personal jurisdiction issue was real and all consuming, we went to the Supreme Court on that issue in this case. We have been to the highest court on the land on the question of where can we sue? That's it. We're not asking, did Ford design a defective product? We're not asking, does they have enough evidence? We're not asking any of those questions, right? So we're not trying to analyze whether or not Ford did a bad thing. We're not trying to analyze whether or not there's enough evidence to prove. We're just simply trying to ask the where question, just like we were in Toddy without a crystal ball. And this case went to the U.S. Supreme Court. Okay, great. So Ford made a car. The the car rolled over, someone died, their estate wants to sue in Montana. The accident occurred in Montana, the person died in Montana, their estate is in Montana, they want to sue in Montana. Fine. All right, so the question is, can they do that? Ooh, right? So here is what we knew before going into this lawsuit. All right, we knew this particular car, and that goes into the question of how particular is particular jurisdiction, right? General type and specific type, or how specific. We have general and specific type. How specific is specific? So this specific car that had this accident was built in Kentucky, and it was sold in Washington. And a company, so there's specific jurisdiction there. We know there's specific jurisdiction in Kentucky. We know there's specific jurisdiction in Washington. Ford definitely did enough stuff in those states. How about general jurisdiction? Well, for businesses, this is well established. A business has general personal jurisdiction, or you have personal jurisdiction against a business in its place of incorporation and its place of personal business. So that gets you Delaware, and that gets you Michigan, right? So we knew we could sue them in Delaware or Michigan under general jurisdiction. We knew that we could sue them in Kentucky or Washington under specific jurisdiction. And then the question is, can we sue them in Montana? And here was the rub. Ford didn't do anything with respect to this specific car in Montana. They didn't sell the car in Montana. They didn't service the car in Montana. Ford themselves didn't do anything with respect to this particular car in Montana. So that's the question here. Can we sue them for this specific car when Ford themselves didn't do anything with respect to this particular car inside of Montana, right? The question isn't can we sue at all, right? So this person wouldn't be SOL'd, right? Because we just discussed this. We can always sue in Michigan. We can always sue in Delaware. We got that for sure. We can sue in Kentucky. We can sue in Washington. So it wouldn't be a person SOL'd. It's just, can we sue specifically in Montana? Great. So when we covered this case in oral argument, I thought the question was very interesting, and I didn't think there was an obvious answer. But after thinking about it and after looking through it, I was of the opinion that the answer was no, Ford could not be sued in Montana. Because it gets again to this question of what exactly do we mean by specific? How specific do we have to be? And I was of the opinion, after looking at this is just a straight up legal opinion, what the best answer is. I was of the legal opinion that the answer was no. For it to be specific, it has to be related to the product in question. Because the alternative would be, presumably, that Ford could be sued anywhere for any of its specific products, which sounds suspiciously like general jurisdiction at that point, right? If Ford can be sued anywhere for any of its products, how is that different from general jurisdiction? So the problem with saying, yes, Ford can be sued here, in my mind, was that combined and conflated personal jurisdiction and specific jurisdiction. If you said yes, it looks just the same as general jurisdiction. And so I'm like, well, that doesn't seem like that can be the right answer. These are obviously two different concepts. And if these answers are the same, then we've kind of eroded the concept, right? So that was my answer. Well, the U.S. Supreme Court disagrees with me. The U.S. Supreme Court says, yes, you can sue in Montana. So they did say it in a 5-3 decision. So 3 members of the court agree with me for whatever it's worth. But the majority, 5 members of the court, say I'm wrong. So we're going to read the U.S. Supreme Court's opinion, and we're going to see a couple things, I suppose. We'll see how good their reasoning is unto itself, and we'll also see if I'm persuaded by it. Because I wasn't exactly sold on the answer being no, but I thought it was the best answer, so we'll see if I'm sold. Does the Supreme Court convince me? Okay. I know that's a lot of preamble, by the way, but I didn't know how to really summarize the issue any better. So if anyone in the chat at this point says, what is this case about? You guys can figure out amongst yourselves, because I'm not going through all that again. Okay, fine. So let us Start reading this case and try to figure out what it does or does not teach on this question of when we say specific jurisdiction, what do we mean by specific? All right, great. So here is the opinion written by Justice Kagan. In each of these two cases, because there was a different case not in Montana that is basically the same issue, a state court held that it had jurisdiction over Ford Motor Company in a products liability suit stemming from a car accident. The accident happened in the state where the suit was brought. So the accident happened there. The victim is in the state. And Ford did substantial business in general in the state, among other things, advertising, selling, and servicing the model of vehicle the suit claims is defective. Still, Ford contends that jurisdiction is improper because the particular, or maybe to phrase it slightly differently, the specific car involved in the crash was not first sold in the forum state, nor was it designed or manufactured, nor like literally anything else. It wasn't serviced there, it wasn't resold by Ford there, anything. All right, so the Supreme Court says no, Ford can be sued here. Okay. When a company like Ford serves a market for a product in a state, and that product causes an injury in the state to one of its residents, the state courts may enter and entertain the resulting suit. All right, so that's the conclusion. That's the bottom line conclusion for all of you guys who want to know about that stuff. There's a car alarm going off in the distance, which is always super fun. Okay. Ford is a global auto company. It is incorporated in Delaware, general jurisdiction. Headquartered in Michigan, general jurisdiction, Delaware, Michigan. But its business is everywhere. Ford markets, sells, and services its products across the United States and overseas. In this country alone, the company annually distributes over 2.5 million new cars, trucks, and SUVs to over 3,200 licensed dealerships. Ford also encourages a resale market for its products. Almost all of its dealers buy and sell used Fords, as well as selling new ones. To enhance its brands and increase its sales, Ford engages in wide-ranging promotional activities, including television, print, online, and direct mail advertisements. No matter where you live, you've seen them. Have you driven a Ford lately or built Ford Tough? I guess I'm not sure whether or not the Ford is pleased or not that its slogans are within the context of a Supreme Court opinion. Is that good advertising or bad advertising? The people of Ford can figure that one out. Ford also ensures that consumers can keep their vehicles running long past the date of sale. The company provides original parts to auto supply stores and repair shops across the country. Goes another slogan, keep your Ford a Ford. Hadn't really heard that one before, so. And Ford's own network of dealerships offers an array of maintenance and repair services, thus fostering an ongoing relationship between Ford and its customers. All this is true in general. Right? Accidents involve two abortive wars in the two respective states in the two respective suits. A 1996 Explorer and a 1994 Crown Vic. At the heart of the suits before us, one case comes from Montana. Markea Gouliette was driving her Explorer near her home in the state of Montana when the tread separated from her tire. The vehicle spun out, rolled into a ditch, and came to rest upon upside down. Gouliette died at the scene of the crash. The representative of her estate sued Ford in Montana State Court, bringing claims for design defect, failure to warn, and negligence. Your standard run-of-the-mill product liability suit. The second case comes from Minnesota. Adam Bandemir was a passenger in his friend's Crown Vic, traveling on a rural road in the state to a favorite ice fishing spot. When his friend rear-ended a snowplow, that's not going to be good, this car too ended in a ditch. Bandemir's airbag failed to deploy and he suffered serious brain damage. He sued Ford in Minnesota State Court, asserting product liability, negligence, breach of warranty. Their standard, run-of-the-mill product liability suit. Ford moved to dismiss these two cases for lack of personal jurisdiction. The personal jurisdiction issue that is on everyone's lips. This is all about personal jurisdiction. Eat your heart out, Toddy. Eat your heart out without a crystal ball. Personal jurisdiction makes its way all the way to the top. According to Ford, the state court, whether in Minnesota or Montana, had jurisdiction only if the company's conduct in that state gave rise to the claim, if the conduct related to this product. Ford continued only if the company had designed, manufactured or sold the state in particular vehicle involved in the accident, or possibly serviced or something, but nothing in Montana, right? At least. I don't know about the full facts in Minnesota, whether it's different. I don't know if they had serviced the vehicle or resold the vehicle in Minnesota, so maybe the facts are slightly different, but in neither suit could the plaintiff make that showing. Yeah, Ford didn't touch the car in that state. Ford had designed the Explorer and Crown Vic in Michigan at its corporate headquarters, and it manufactured the cars, respectively, Kentucky, the Montana case, and Canada, the Minnesota case. Still, the company had originally sold the cars at issue outside of those states, originally selling the cars for the Explorer in Washington and the Crown Vic in North Dakota, which is neither Minnesota nor Montana. One will take notes. Only later resales and relocations by customers had brought the vehicles to Minnesota and Montana. So it wasn't Ford's doing that this car wound up in Montana. It was things that happened after the fact. So there's some sort of first sale doctrine here idea, right? Ford is not liable, so the argument goes, after the first sale, unless they at some point do something to create liability for them. So that's sort of the idea. That means, in Ford's view, that the courts of those states could not decide the suit. Seemed like the best legal answer to me, because the alternative seems to conflate personal specific jurisdiction and personal general jurisdiction. Both the Montana and Minnesota Supreme Courts rejected Ford's argument. So both of the states' courts said no. The Montana court began by detailing the various ways Ford purposely seeks to serve the market in Montana, which I don't think anyone is going to contest. But this, to me, sounds a lot like the idea of sufficient minimum contacts, which doesn't seem like it's quite the right issue here. But yes, I don't think anyone's going to argue that Ford doesn't have sufficient minimum contacts in general. The company advertises in the state, has 36 dealerships there, sells automobiles, specifically the Ford Explorer, which is the same car that was at issue in Montana. Not this specific car, but same model. And parts to Montana residents and provides them with certified repair, replacement, and recall services. Next, the court assessed the relationship between those activities and the suit. Okay. Ford's conduct, says the court, encourages Montana residents to drive Ford vehicles. In general, sure. When that driving causes in-state injury, the insuring claims have enough of a tie to Montana's activities to support jurisdiction. And that's the conclusionary aspect, right? So that's the ultimate conclusion that I disagreed with, right? So I agreed with all the premises. I just disagreed with the conclusion. Whether Ford designed, manufactured, or sold the particular vehicle in the state, the court concluded is immaterial. Yeah, or I thought it was material, right? That's just a sort of end conclusion. Does it matter or not? I thought it mattered. They think it doesn't matter. I said it does matter. And the Supreme Court just said, no one cares. No one cares about this issue. So, I guess I got told on that one. Minnesota Supreme Court agreed. It highlighted how Ford's marketing and advertising influenced state residents to purchase and drive motor vehicles. Indeed, Ford had sold in Minnesota more than 2,000 Crown Vics, the very same type of car involved in the suit. That particular vehicle injuring him was sold elsewhere, made no difference. Right? That's the end conclusion. Does it matter or not? I said it does matter. The Supreme Court says no one cares. In the court's view, Florida's Minnesota activities still have the needed connection to the allegations that defective Crown Vic caused in-state injury. We grant certiorari to consider this issue. And we hold that the state Supreme Courts in this case were exactly right, and Uncivil Law was apparently wrong. Very sad for me. The 14th Amendment's Due Process Clause limits a state's court's power to exercise jurisdiction over a defendant. The canonical decision in the area remains International Shoe, a case that is well known to every law student ever. International Shoe. It resonates right off the tongue. There, the court held that tribal authority depends, tribunal's authority depends on the defendant having such contacts right, within the forum that the maintenance of the suit is reasonable in the context of the foreign government and does not offend traditional notions. This is sufficient minimum context. That's international shoe. Yeah, that's basically the exact same issue in Toddy without a crystal ball. This issue, the canonical issue, was 1945 international shoe, a case that is well known in law land. It's like a shibboleth. So, next time you want to pretend to be a lawyer, it's like, hey, what do you think about international shoe? I don't know. They actually kind of think you're pretentious if you say that, so maybe not that one. In a given context to that formulation, the court has long focused on the nature and extent of the defensive relationship to the foreign state. That focus led us to recognize two kinds of personal jurisdiction, general and specific. Right? This is what I've been talking to you about. That was what my entire introduction was trying to explain. Personal jurisdiction comes in these two varieties, general and specific. Great. A state court may exercise general jurisdiction over only when a defendant is essentially at home in the state. General jurisdiction, as the name implies, extends to any and all claims brought against the defendant. Those claims need not relate to the forum state or defendant's activity there. They can be from anywhere, anything. They may concern events and conduct anywhere in the world, let alone the United States. Anywhere, anything, general. But the breadth imposes a correlative limit. Only a select set of affiliations within a forum will expose a defendant to the all the things jurisdiction. Yeah, because you're subject to all the things, the courts say only in very limited places. And as I mentioned in the case of a corporation, those places are the place of incorporation and the place of principal business, which in this case are Michigan and Delaware. It's not that clean for a person, but it is that. I mean, their legal state of domicile is certainly the place, no doubt. So, but it's not clear where else it extends to in the case of a personal thing. So the reason I asked this question, incidentally, the reason that I don't think there's a clean answer on this is the idea of a person who has a vacation home and maybe they spend half their time there, or maybe more, because the place where you live most of the time doesn't necessarily have to be your place of domicile. So your place of domicile could be New York, but you spend 10 months of the year in Florida. Do you have general jurisdiction in Florida? I don't know. It's not that clean when it comes to people. So when you have that kind of situation, we don't know. But we do know what it is in corporations. Is the place of incorporation is the place of principal business. Great. Got that sold. And what we have called the paradigm case, Daimler, which is Mercedes-Benz, right? Mercedes-Daimler. An individual subject to general jurisdiction in their place of domicile. And equivalent forms for a corporation. Yeah, so we've concluded general in the place of domicile. But I don't think the Supreme Court has ever said it's strictly limited to that. That's my question. So we do know it's the place of domicile, but I'm not quite sure about our situations. And the equivalent forms for a corporation are its place of incorporation, principal place of business, as I said. So general jurisdiction over Ford attaches to Delaware and Michigan, not Montana and Minnesota. This much, I think, we all agreed on going in. We do not have general jurisdiction in Montana and Minnesota. And that's why I thought the answer to this question ultimately would be no. Because again, if the answer was yes, it would suggest, as a practical matter, specific jurisdiction is the same as general. So let's see if that's true and go on. Specific jurisdiction is different. It covers defendants less intimately connected with the state, but only as to the narrower class of claims. The context for this type of jurisdiction often go by the name purposeful availment, also known as minimum context. That's Burger King. This defendant, we've said, must take some act by which it purposely avails itself of the privilege of conducting activities within the foreign state. The context must be the defendant's own choice and not random, isolated, or fortuitous. Where does this language sound familiar? Where does this language sound familiar? Of not random, isolated, and fortuitous. Didn't we see this exact language very recently in the Toddy without a crystal ball case? Yes, we did. Yes, we did. They must show the defendant deliberately reached out beyond its home, for example, by exploiting the market in the forum state or entering into a contractual relationship that's centered there. Yet even then, because the defendant is not at home, the forum state may exercise jurisdiction only in certain cases, not all the cases. Because you can be sued there for some things doesn't mean you can be sued there for all things. It's not general. And this is the key. The plaintiff's claims, as we have often stated, must arise out of or relate to the defendant's contacts within the forum. That's the key language here. And that's where I thought this is tripping up for me, right? We must arise out of or relate to the defendant's contacts within the forum. So my question when I was trying to analyze this for myself is, in what sense did this particular Ford Explorer, right, this particular accident, how did that arise out of or relate to Ford's contacts within the forum? That was my problem, right? This is exactly where my analysis was pinned on. We know it has to arise out of the defendant's contacts with the forum. And then in what sense is that true in this case? The car wasn't sold there. It wasn't maintained there. Ford didn't touch this car in Montana. So how did it arise out of Ford's actions in Montana? Right? That was where I got tripped up. Or that's what I based my answer on. Or to put it a bit differently, there must be an affiliation between the forum and the underlying controversy, particularly an activity or an occurrence that takes place in the forum state. An activity, an occurrence that occurs within the forum state. What would that be with respect to this particular 1996 Ford Explorer? Hopefully me going over this somewhat laboriously is helping you to understand why I came to the answer I did, right? So this is me trying to explain my legal thinking and how I analyzed the question and why I came out the way I did. The reason I'm spending as much time on this as I am is to show you how I approached the problem and how I was reading the case law and why I came to certain conclusions that I did, right? So this is about me showing you the internal workings of my thought process. So hopefully you can understand better how I came to the conclusions I did. This is the language I was relying on. This is my analysis. This is why I came to the end conclusions I did. Hopefully all that somewhat makes sense. These rules derive from and reflect two sets of values: treating defendants fairly and protecting interstate federalism. Our decision in International Shoe founded specific jurisdiction on the idea of reciprocity between defendant and estate when, but only when, a company exercised the privileges of conducting activities within the state and thus enjoying the benefits and protections of its laws. The state may hold a company to account for related misconduct. How related? Later decisions have added that our doctrine similarly provides defendants with fair warning, knowledge that a particular activity may subject it to jurisdiction in the foreign sovereign or the foreign states. Right? I'm not coming up with this legal analysis from nowhere. A defendant then can thus structure its primary conduct to lessen or avoid exposure to given courts. And the court has considered alongside each defendant's interest those states in relation to each other. One state's sovereign power to try a suit, we have recognized, may prevent sister states from exercising like authority. Possible. I mean, yeah, once an issue is decided by one state, full faith and credit, may very well preclude another state from hearing that issue. Yeah. The law of specific jurisdiction thus seeks to ensure that states with little legitimate interest in the suit do not encroach on states more affected by the controversy. So there's that too, right? So it's not only the interest of the defendant, it's also interests of the government. because if anywhere can hear this suit, and we have full faith and credit, as we do, then that would mean that a state that is completely tangential from this could theoretically take the issue away from a state where it's more core. So there's a problem there too. So there's that angle. Hopefully that makes sense. Okay, great. Let me just check in with the chat. I haven't seen any questions so far, but I just want to see where we're going. Let me just see what's going on in the chat so far. So if you have questions, as always, just remember to start your question or your comment with @Uncivil Law or the word question, so it'll pop up in my feed. So this, the electrical points, for the record, watching Critical Role. I appreciate that. That's really nice. Matthew says, really enjoying this analysis. Thank you. I'm trying to explain it very thoroughly to show you how at least this lawyer thinks and what kind of thought process I go through. Sapper says this is confusing as all get out. It's pretty confusing, which is one of the reasons that I'm repeating myself as much as I am. I'm trying very desperately to explain it by coming at it from a couple different perspectives and highlighting it every time it comes up. So that's one of the reasons I'm so repetitive, because that was I haven't seen that comment in a while, but I used to see that comment a lot in my YouTube videos. Why you're so repetitive? It's partially because when I think something's important, I want to make sure you heard it, because I think it's important, right? Con law flashback. Yeah, this is con law flashback big time. Yeah. This is why you pay lawyers, because Joe Normal will never understand him, maybe. Ford made specific choices by advertising in those states. Yeah, we are very clear on that. But the problem isn't that Ford made specific choices to buy the advertising, but how does that choice relate to the accident? That's the problem. How did the advertising, or at least the problem for me, how did the advertising in Montana relate to the car? Right? It was bought in Washington. I'm going to take a flyer and assume the ads they ran in Montana had nothing to do with the vehicle purchase in Washington. So yeah, they made the choice to do that, but how's that related to this? How's that specific and not general? Question, what state law would apply? The place of the accident. So it would be Montana. Well, I'm not sure if that's 100% true. In product liability law, I don't know. We'd have to get into choice of law principles. We don't have time for that right now. Choice of law principles, I'm not super familiar on, because it never comes up for me. I don't have this problem, because I deal with federal law, so I don't have to worry about choice of law. So it's not something I know as well. So I'm going to take a pass on that one as to which state law. Thank you for the analysis and breakdown. Take my money. I appreciate that. Do you have any guess for the reason behind their decision at this point? No, not yet. So far, we've laid out the conclusion. We've laid out the conclusion, and we've laid out the reasoning, but we haven't really gotten into, connecting the dots. Here are all the facts. Here's all the prior case law. But the Supreme Court hasn't yet gone into, here's all the prior facts, here's all the prior facts, here's all the prior law. Supreme Court yet hasn't gotten into how do these facts relate on this law. I've gotten into that. I've explained how it reads for me. The Supreme Court hasn't got its reading, so I got nothing yet. Joe O'Neill says, would the fact the state owns the bill of origin make them culpable? The state owns the bill of origin. I don't know what that means. Do you mean like the idea that it's registered in Montana? I wouldn't think so, because Ford didn't do anything to cause it to be registered in Montana. I'm not sure what you mean by the state owning the bill of origin. Kiki says, looking good. Halo vitamin review? Maybe, and thank you. I've been losing a little weight, and I appreciate you noticing. Thank you. Okay, Ford contends that our jurisdictional rules prevent Montana and Minnesota's courts from deciding these two particular suits. In making that argument, Ford does not contest that it does substantial business in Minnesota and Montana, like no duh, that actively seeks to serve the market for automobiles and related products in those states. Or to put the concession in more doctrinal terms, Ford agrees it has purposely availed itself of the privilege of conducting activities in both those places in general. Ford's claim is instead that those activities do not sufficiently connect to this particular suit, even though the residents allege that cars malfunctioned in the farm state. But that's kind of happenstance, right? Remember that language we saw from earlier about random happenstance kind of things? The fact that it failed in Montana as opposed to anywhere is happenstance. If there was a defect, if the product was defective, presumably it was defective the moment it came off the line. So, that would be that. In Ford's view, the needed link must be causal in nature. Jurisdiction attacks only if the defendant forum conduct gave rise to the claim. Right. Has to be causal. Something Ford did has to be the causal thing. Anything would be fine. Or maybe not. Maybe not anything, but, at least something that they did. So maybe there's a possibility that Ford could do some specific thing that wouldn't be enough, but we don't need to get into that right now because they didn't do anything specifically. Also, it doesn't matter at this point because the Supreme Court's about to tell me that doesn't matter, so whatever. So on that view, the place of accident and injury is immaterial. Right. The issue is product liability, product defect. The place of the accident would be immaterial, presumably because the product defect occurred in the design stage, or it occurred when the car was manufactured. That makes sense to me. So Ford says Montana and Minnesota courts have no power over its cases. That seems logical. All right, the Supreme Court is about to say why it doesn't. It's not logical. So this is the part where the Supreme Court's going to start trying to persuade me that I'm wrong, and we'll try to keep an open mind as much as we can. But Ford's causation-only approach finds no support in this court's requirement of a connection between the suit and defendant's activities. That rule indeed serves to narrow the class of claims over which a state court may exercise specific jurisdiction, but not quite as far as Ford wants. None of our precedents have suggested that only a strict causal relationship between defendants' in-state activity and litigation will do. I guess that's kind of true, but it does seem to be the implication, at least the way I read it. I mean, no case said it, that's true. And just noted, our most common formulation of the rule demands the suit arise of or relate to defendant's contact of the forum. How does it relate to? The first half of that standard asks about causation. But the back half, after the or, contemplates some relationship that will support jurisdiction without causal showing. Okay, so the Supreme Court says arise out of is a causal thing. Related to is non-causal. They might be right about that, I suppose, but it's still, what's the nature of the relationship, right? So maybe it isn't causal, but it has to have, maybe this is sort of like, maybe this is Paul's graph with the dynamite on the train, and maybe it's an idea of something being too attenuated to count. So maybe we're about to go into some Paul's graph kind of idea here. All right. That doesn't mean anything goes. In the sphere of specific jurisdiction, the phrase relates to incorporates real limits, as it must adequately protect defendants foreign to the forum. But we never phrase specific jurisdiction inquiry as always requiring proof of causation, proof that plans came about because of defendant's in-state conduct. That's true. You've never explicitly framed that way. Yeah. So this case is not over, even if, as Ford argues, a causal test will put jurisdiction only in the case of first manufacture. A different courts may yet have jurisdiction because of other activity occurrence involving the state. I suppose, if it's related to, whatever that means, and then we have to get into what related to means. So sure, we'll accept for the moment, at least. That related to doesn't require causality, and so maybe we can be more attenuated. And maybe we're getting to some Paul's graph limits or something at some point. Indeed, this court has stated the specific jurisdiction attaches in cases identical to the one here, when a company like Ford serves a market for a product in a foreign state and the product manufactures there. In worldwide Volkswagen, which is also a super famous case on personal jurisdiction, the court held that an Oklahoma court could not assert jurisdiction over a New York car dealer just because the car it sold later caught fire in Oklahoma, which seems like kind of the same thing, right? So the car caught fire in Oklahoma. The New York car dealership might have some product liability, and the place that caught fire is one of those random things. So yeah, Volkswagen kind of suggests against this answer. By doing so, we contrast the dealer's position to that of two other defendants, Audi, the car manufacturer, and Volkswagen, the car's nationwide importer, neither of which contested jurisdiction. The court saying in worldwide Volkswagen, if the sale of a product or manufacturer or distributor, such as Audi or Volkswagen, is not simply an isolated occurrence, but arises out from efforts of manufacturer distributor to serve directly or indirectly the market for its products in several or other states, is not unreasonable to subject to suit in one of those states if it's allegedly defective merchandise that has been there the source of injury. So that language suggests this answer. Or said another way, if Audi and Volkswagen's business deliberately extended into Oklahoma, as among other states, then Oklahoma courts could hold the companies accountable for a car catching fire, though, even though the vehicle had been designed and made overseas and sold in New York. That language does appear to support that proposition. That's a reasonable reading of that language. For example, the court explained a company thus purposely availing itself of the Oklahoma market has clear notice of exposure in states to suits arising of local accidents involving its cars. And the company could do something about that exposure. It could act to ameliorate the risk of burdensome litigation by procuring insurance, passing to expect the cost on the consumers, or if the risks are too great, severing its connection with the state. Okay. Our conclusion in worldwide Volkswagen, though, as Ford notes, is technically dicta. Yeah, it wasn't critical to the case. And there's a lot of other language that seems to counsel against. But this has appeared and reappeared in many cases. So, for example, the court in Keating invoked that part of worldwide Volkswagen to show why a corporation has continuously and deliberately exploited a state's market. It must reasonably anticipate being hauled in that courts to defend actions based on product injury causing there. On two other equations, we reaffirm that rule by reciting the above quoted language verbatim. And in Daimler, which is Mercedes, we use the Audi Volkswagen scenario as a paradigm of the specific jurisdiction, though now naming Daimler the maker of Mercedes-Benz. Yeah. Said a court, to illustrate specific jurisdiction's province, a California court would exercise specific jurisdiction if a California plaintiff, injured in a California accident involving a Daimler manufactured vehicle, sued Daimler, alleging the vehicle was defectively designed. So that language appears to support this conclusion. Okay. As worldwide Volkswagen, the court did not limit jurisdiction to where the car, As to worldwide Volkswagen, the court did not limit jurisdiction where the car was designed, manufactured, or first sold. Substitute Ford for Mercedes, Montana and Minnesota for California, and the court's illustrative case becomes the same. That seems to be fair. To see why Ford is subject to jurisdiction in these cases, as Audi, Volkswagen, and Mercedes were, in their analogs, consider the first business the company regularly conducts in Minnesota and Montana. Small wonder that Ford here has conceded purposeful availment. By every means imaginable, among them, billboards, TV and radio spots, print ads, direct mail, Ford urges Montanians and Minnesotans to buy its vehicles, including the Explorers and Crown Vics. Ford's cars, again, including those 2 models, are available for sale, whether new or used, throughout the state at 36 dealerships in Montana and 84 in Minnesota. And apart from sales, Ford works hard to foster ongoing connections to its owners. The company dealers in Minnesota and Montana and elsewhere regularly maintain and repair Ford cars, including those whose warranty has long since expired. The company distributes replacement parts both to its own dealers and to independent auto shops in the United States. These activities, too, make Ford money. And then making it easier to own a Ford, they encourage Montanians and Minnesotans to become lifelong Ford drivers. Now, to turn how all this Minnesota and Montana-based conduct relates to the claims in this case, that's the ultimate point of divergence here for me so far, brought by these residents. Each plaintiff suit, of course, arises from a car accident in the forum state. In each complaint, the resident plaintiff alleges that the defective vehicle, the Explorer or the Crown Vic, caused the crash and resulted in that harm. And just as described, Ford had advertised, sold, and serviced the same model in those states. Contrast a case which we do not address, in which Ford markets the model in only a different state or region, which I believe is true for some of Ford's cars. I don't think they sell all their models everywhere. In other words, Ford has systematically served a market in Montana and Minnesota for the very vehicles the plaintiff alleges malfunctioned and issued them in those states. So there's a strong relationship among the defendant, the forum, and the litigation, the essential foundation of which for specific jurisdiction. That's why this court has used this exact fact pattern. A resident plaintiff sues a global car company, extensively serving the state's market, for an in-state accident as illustration, even a paradigm of how specific jurisdiction works. And then there's a little footnote here. Notice this is to say that any person using any means to sell any good in a state is subject to jurisdiction there if a product manufactures there after arrival. So we have long treated isolated or sporadic transactions differently from continuous ones, and we do not consider internet transactions which may raise different questions, which is a bit unsatisfying, I suppose, in the end. This case does not present very different questions of whether and how a defendant's virtual presence and conduct relates into contact with a particular state, which is without a crystal ball. So how this works in the internet world, the court is not going to answer today. So consider a hypothetical offered at oral argument. A retired guy in a small town in Maine carves decoys and uses the site on the internet to sell them. Can he be sued in any state if some harm arises from the decoy? The differences between that case and the one before us virtually list themselves. Just consider all descriptors of Ford's activities outside its home bases. So we agree with plaintiff's counsel that resolving these cases do not resolve that particular hypothetical. So how this relates to the internet world remains a little unclear. If Toddy without a crystal ball winds up at the Supreme Court, I'm going to lose my mind. I don't really think that's going to happen, but, you know. Although this case actually presents not a bad vehicle for it. Vehicle in this sense doesn't mean car. It means a good case to resolve the issue. I don't know if it's the greatest vehicle, but it could be good. The only complication here presented by Ford is that the company sold specific cars involved in these crashes outside the forum states, with consumers later selling them to state's residents. Because that is so, Ford argues the plaintiff claims would be precisely the same if Ford had never done anything in Minnesota and Montana. Of course, that argument merely restates Ford's demand for an exclusive causal test of connection, which I've already shown is inconsistent with our case law. Indeed, a similar assertion could have been made in worldwide Volkswagen, yet the court made clear that systematic connection in Oklahoma rendered Audi accountable for an in-state accident even though the car was sold in New York. So too, and for the same reasons, that without the company in Minnesota or Montana contacts, the plaintiff would have been just the same. But in any event, the assumption is far from clear. For example, the owners might have never bought them, and so the suits might have never arisen except for Ford contacts with their home state. Those contacts might turn any resident of Minnesota and Montana into a Ford owner, even if he buys it from out of state. He may make the purchase because he saw the ad for a car in local media. He may take into account a raft of Ford in-state activities designed to make driving Fords convenient. Ford dealers stand ready to service the car, that other auto shops have ample supply of Ford parts, that Ford fosters an active resale market. The plaintiff here did not in fact establish or even allege these causal links, nor should jurisdiction in these cases ride on the exact reasons for an individual's purchase or his ability to present persuasive evidence about them. But the possibilities listed above, created by the reach of Fords in Montana and Minnesota, underscores the aptness of finding jurisdiction here, even though the cars at issue were first sold to the state. For related reasons, allowing jurisdiction in these cases treats Ford fairly, as the court's precedent explains. In conducting so much business in Montana and Minnesota, Ford enjoys the benefit and protection of those states' laws. Sure. For the stuff they're doing in those states, of course. Yeah, that makes sense. And then they would be liable for the things that happened in those states, right? So they get the benefit of the state law and they get the downside of the state law for things that happened in that state. That seems logical enough. All this assistance to Ford Interstate's business creates reciprocal obligations. Most relevant here, that the cars models Ford so extensively markets be safe for their citizens to use. Thus, our repeated conclusion. A state court enforces of that commitment, enshrined as it is, with Ford's government-produced in-state business can hardly be said to be undue. Yeah. In the words why Volkswagen described, it cannot be thought of surprising either. An automaker regularly marketing a vehicle in the state, the court has clear notice that will be subject to the jurisdiction courts when the product manufactures there, regardless of where it is first sold. Precisely because the exercise of jurisdiction is so reasonable, it also predictable, and thus allowed Ford to structure its primary conduct to lessen or even avoid the costs of state court litigation. Finally, the principles of interstate federalism support jurisdiction over these suits. These states have significant interests at stake. Providing their residents with a convenient forum for redressing injuries inflicted by out-of-state actors, as well as enforcing their own safety regulations. Okay, here's my problem. Obviously, these states have at least in a practical sense, they have a very strong interest because the vehicle accident occurred there and the vehicle's driving on its roads. So the state's interest, I don't think, is a problem. But we're not analyzing personal jurisdiction from that angle. We're analyzing it from the position of Ford. So I'm not necessarily sure why. Well, I can actually tell you a reason why, because because the laws are better. But it might, if the idea is that because Ford does enough stuff in that state in general, does that imply that the person who's in the accident can sue related to that accident anywhere? And the reason that you might want to is because the laws in that state would be more favorable. Or is the court saying, well, you can't do that because the accident only occurred in one place? And so even though Ford, see, that's the problem, because we're looking at this from the position of what Ford did or didn't do, right? So if we're looking at this from the position of what Ford did or didn't do and how it's fair to Ford, then Ford, we'll just take it as a given that Ford has dealerships everywhere, that Ford does advertising everywhere, that Ford has services everywhere, that Ford fosters its relationships with pre-owns everywhere, right? So we'll just take that as a given. So if we're looking at this as a position from what's fair to Ford, and it's like, well, because you sold cars like this, you were on notice that you could be sued concerning that car. That would imply, potentially, that Ford could be sued concerning that accident everywhere. And then the only limiting principle there would be to say, well, the accident didn't occur in Rando State. But then again, the accident occurring in Rando State does seem to be one of those random events that we alluded to before, right? We don't really allow personal jurisdiction based on random fortuitous events. If the car was defective, it was defective. The fact that the accident occurred here and not there is just a fortuitous issue of chance or a fortuitous random thing. And we don't do jurisdiction based on that. So trying to limit this to only the place where the accident occurred seems odd, because you're limiting it specifically based on one of these random fortuitous things, as opposed to the non-random, non-fortuitous things, such as their regular dealings. So it's not immediately obvious to me why the accident occurred here is necessarily a limiting principle under this logic. I mean, hopefully some of that makes sense about why I'm saying that, right? I always want to try to explain my thinking, because you're like, well, the accident didn't occur in Rando State, so why would the state have jurisdiction? But the fact that the accident occurred here and not there is like, it's just a happenstance. And we don't do jurisdiction based on happenstance, so why is that a limiting principle is not immediately obvious. There's a couple of questions. Could this be the real reason Toddy moved back to Washington? For jurisdiction? I doubt it. I mean, I don't think people make movements based on where the jurisdiction issues. IRS merger. Enforce safety laws. Doesn't that imply the automaker needs to follow the safety law from the states the car is not made sold in? Well, yeah, but but the car didn't fail because of a safety law issue. It failed because the product was allegedly, because again, this is all alleged, right? We don't know whether or not any of this is true, because we're trying to figure out the where question. This is all based on a product potentially defecting. So that doesn't really have anything to do with safety law. So I don't see the connection there. Squeal 16 says, how would this work with shared designs like Toyota Supra, co-designed with BMW? Each has their own version, but there are large similarities in shared chassis. Well, I would presume that in that kind of case, where both companies are collectively designing, that they both would be liable. And they might both be liable for the other manufacturer too. So that'd be interesting. So you have the, and then you also have the Subaru Toyota for the BRZ, right? So if a Toyota 86, which is what they call it, if a Toyota 86 goes wrong, can you sue Subaru because they helped design? Maybe. Actually, that would make more sense than this to me. Because if there's a design defect, then and Subaru was part of the design team, then they would have liability. So yeah, actually, if the Toyota 86 failed due to a design flaw, then you could sue Subaru because they had a hand in the design. That would actually make more sense to me than this, for whatever it's worth. Finally, principles of interstate federalism support jurisdiction. Yeah, we discussed that. For each of these states, the suit involves all out-of-state parties, an out-of-state accident, and out-of-state injuries. The suit's only connection with the state is the former owner once, many years, bought a car there. All right, I skipped a sentence. Consider next those the interest of the state's first sale, Washington and North Dakota, which Ford proposed rule would make the most likely forms. Well, I don't know about that. You could also do the places where they were designed, which is Canada and Detroit, the places where they were built, which is Kentucky and something, and you can always sue them in their corporate headquarters. So for each of those states, the states involves all out-of-state parties. No, this Ford would be, well, yeah, I guess they're kind of out-of-state, but whatever. Yeah, they're out-of-state parties, an out-of-state accident, and out-of-state injuries. The source's only connection is the former owner once, many years earlier, bought the car there. Yeah, in other words, there's less significant relationship among the defendant, the foreman, and the litigation. No, I'm not sure that follows. It would certainly be less relationship with respect to the plaintiff, but I think it's a more relationship with respect to the defendant, because defendant did more stuff there. They sold the car there. That's more stuff. They didn't do anything with respect to the car in Montana. So yeah, they once sold the car there, but if the car was defective, that's more than enough in my view. So I'm not sure I agree that there's less causal connection in that case. So by changing these suits to Washington, North Dakota, Ford's regime would be undermined rather than promote what the company calls due process for jurisdiction allocating functions. I don't agree with that. I don't agree with that. Because they did something specific with respect to that car. So they designed the car, they sold the car. I mean, that's purposeful. We definitely have enough minimum contacts, right? So we definitely have enough minimum contacts. We're definitely doing enough stuff in general in that state, so we don't have that problem. And then we sold the specific car in that state. So I don't think that's less due process. It's like we made the decision to sell that car in that state. That seems... I think Ford has the better end of the argument. Or maybe I just disagree with Kagan's reasoning. Maybe there's a better reasoning that makes more sense, but Kagan's reasoning is not quite doing it for me. What's the next step in the Toddy lawsuit? Well, I think as a practical matter, the next step is to refile. I really doubt very much they will appeal the jurisdiction issue, but as you see, they could. Bellarmore said, could this apply to online content platforms as their presence in every state? Yeah, the Supreme Court in footnote 4, which we read earlier, the Supreme Court in footnote 4 made a point of saying, we are not answering the question of how this applies to internet world. So, I don't know. The Supreme Court said, we're not answering how this applies to the internet world right now, because we don't know. Ford mainly relies on its rule for two of our recent decisions, Bristol-Myers and Walden. But those precedents stand for nothing like the principle Ford derives from them. If anything, they may reinforce all the more while we decide this case. Ford says that Bristol-Myers squarely forecloses jurisdiction. In that case, a non-resident plaintiff brought claims in a California state court against Bristol-Myers, the manufacturer of a nationally marketed prescription drug called Plavix. The plaintiffs had not brought Plavix into California, and neither of them used or suffered any harm from the drug there. Still, California Supreme Court thought it could exercise jurisdiction because Bristol-Myers sold Plavix in California, and they were defending against identical claims brought by the state residents. So, yeah, it seems very similar, right? We are selling Plavix compared with we are selling Ford Explorers in California. We did not bring this drug into California. We did not bring this car into Minnesota or Michigan or wherever. Not Michigan because general jurisdiction, but the court disagreed, holding that the exercise jurisdiction violated the 14th Amendment. In the Ford's view, the same must be true here, which seems kind of logical. Each of these plaintiffs, like the plaintiffs in Bristol-Myers, alleged injury from a particular item, which is a car versus a pill, defendant had sold outside the forum state. Ford reads Bristol-Myers to preclude jurisdiction when that is true, even if the defendant regularly sold the same kind of product. I mean, that seems like a fair reading of that. But that risking misses the point of our decision. We found jurisdiction improper because the forum state and defense activity that lacked any connection to the plaintiff's claim. I don't understand the distinction. We found jurisdiction improper in Bristol-Myers because the forum state and defendant's activities there, which would be Bristol-Myers or Ford, lacked any connection to the plaintiff's claim. What is needed and what is missing is a connection between the forum and the specific claim at issue. The plaintiffs, the court explained, were not residents of California. Yeah, but why does that matter? Because personal jurisdiction doesn't rely on where the plaintiffs live. They had not been prescribed it in California. The car wasn't sold there. They weren't advertised it there. They had not ingested Plavix in California. Not sustained injuries in California. In short, the plaintiffs were engaged in forum shopping, suing in California because they thought it was plaintiff-friendly, even though their case had no tie. That is not true of the cases before us. Well, you can split the difference between the two. That's fair enough. Yes, Ford sold specific product in other states, as Bristol-Myers had, but here the plaintiffs are residents of the forum state. I don't know why that matters, because when we're talking about personal jurisdiction, we're talking about the defendant. So I don't know why it matters that the plaintiff has residency in the state. That's not what personal jurisdiction is about. They used allegedly defective products in the forum state. That's closer. And they suffered injuries when those products malfunction in that state. That's closer. In some, each of the plaintiffs brought suit in the most natural state, based on affiliation between forum and the underlying controversy, principally, and activity or occurrence that took place there. Ford Facts falls back on Walden as last resort. In that case, a Georgia police officer working at an Atlanta airport searched and seized money from 2 Nevada residents before they embarked on a flight to Las Vegas. The victims of the search sued the officer in Nevada, arguing that their alleged injury, the inability to use the money, occurred in the state where they lived. This court held the exercise of jurisdiction in Nevada improper, even though the plaintiffs experienced effects of the award's conduct there. According to Ford, our ruling shows the plaintiff's residence and place of injury can never support jurisdiction. I don't think plaintiff's residency can. And with those facts, Ford concludes the basis for jurisdiction crumbles this hill. But Walden has precious little to do with the cases before us. In Walden, the only plaintiff had contact with the state of Nevada. The defendant officer never taken an act, form a contact of his own. Defendant never traveled to, conducted activities within, contacted anyone, or seen anyone in Nevada. So he used the language of doctrinal test. He not purposely availed himself. Well, that makes sense. That I buy. And I can distinguish that from the present case. The previous case with Bristol Myers is a little bit less, but this one's more distinguishable. Because that's true, the court had no occasion to address the necessary connection. But here the Ford has veritably truckload of contacts. Ha, ha, ha. Ford has a truckload of contacts with Minnesota and Montana, as it admits. The only issue is whether those contacts are related enough. That is, in fact, the only issue, yes. Are they related enough? As to that issue, so what if the place of plaintiff's injury and residence cannot create defendant's contact within the forum state? Those places may still be relevant in assessing the link between the defendant forum context and the plaintiff's suit, including assertions of who was injured where. Indeed, the relevance is a key part of Bristol Myers' reasoning. One of Ford's own favorite cases list refutes its appeal in the other. Here, resident plaintiffs allege they've suffered in-state injury because of defective products. For all the reasons we've given, the connection between these products is close enough to support specific jurisdiction. And Justice Barrett took no part in the case because Justice Barrett was not on the court at the time that this case was argued. So what was the split on this? Interesting. Let me just take a quick look and see what the split was, because I know it was 5-3, but I didn't know who was where. So give me a second. What was the split on this one? So it was Sotomayor, Kagan, Breyer, Roberts, and Kavanaugh versus Gorsuch, Alito, and Thomas. Interesting. I think Justice Roberts has definitely switched over to the left-hand side of the court these days. I'm not sure he's not the man he was 10 years ago. Okay. Interesting. So let's just I'm just going to skim the dissent. I'm not going to read it, but we'll just skim it. So Alito concurs, should be decided without alteration. Blah, 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 blah. Ford asks us to adopt an presidential rule. Form must be proven. The court rejects that argument. My only quibble is the new gloss the court puts on our case law. Several opinions said plaintiff's claim must arise out of. The court parses this phrase as though we're dealing with language and statute. Because the phrase is cast in a disjunctive, the court recognizes a new category as permitted. Those in which they do not arise out of, but relate to. The innovation is unnecessary. Yeah. Justice Gorsuch, Justice Thomas Dies, concurring in the judgment. International shoe. General jurisdiction, but this power the court must usually entertain is at home in the forum state while clients have admonished. Today's case tests the boundaries. Till now, many cases proceed on the premise that specific jurisdiction requires two things, blah, blah, blah. Blah, blah, blah. While the old international shoe dichotomy is looking increasingly uncertain, I think that's true. I think that's kind of fair. I don't think there's as many holes in the international shoe as elsewhere, but I would say that over the years it's become a little bit unmoored, but I still think there's enough there at the end of the day. Is there anything here worthy of discussion? Not really. So, interesting. I don't know. I mean, at the end of the day, it's a philosophical question, right? There's no like right answer to this, really. It's like, how do you read the case law? And I mean, I think there's case law that kind of reads both ways. So I don't know. I'm gonna have to ponder it some more. I wouldn't say that I'm convinced right now, but I wouldn't say that I'm closed-minded either. So I'm gonna have to ponder this a little bit and think about it over a couple days and see how I think about it. But right now, I would say that I'm unconvinced but open-minded. And we'll see if I firm up an opinion on this. I might have to go reread Worldwide Volkswagen. That's probably a good idea to see if that rereading it informs my opinion. So I wouldn't say that I'm convinced, but I'd say that I'm open-minded. There's enough there to get there. I mean, it's not like the reasoning is defective, right? It's just, do you agree with the reasoning? So, yeah, Justice Kagan's reasoning is reasonable. Her chain of thinking makes sense. She has the support in the case law. But to say that she's reasonable doesn't necessarily suggest there aren't other reasonable opinions that might disagree, because it seems like there's other opinions that go the other way. So to concede Kagan's opinion is reasonable is not to suggest that there is a different contrary opinion that's also reasonable and perhaps better, if that makes any sense. So I'm going to ponder that one for a little while. Yeah. Interesting. Well, this has definitely been a geek out section. We've geeked out pretty hard today on law. We've geeked out hard on some really core principles. We've gone deep into the personal jurisdiction issue, and you all have learned more about personal jurisdiction today than you probably ever wanted to know. Right? And we discussed my reasoning and how I came out. We discussed Kagan's reasoning, and I'm going to have to ponder Kagan's reasoning and see if it makes more sense the more that I think about it. Right? Because, we should be open-minded. So, and don't know yet how I feel about it. She might win me over yet, just not today. Cool. That was fun. If you're enjoying this legal education content, please remember to like the video on your way out. I do these videos for you, and I certainly enjoy them, and I hope you find them interesting, because you get to see the deep dives of law. So if you found this really geeky, deep discussion on the very, very fine points of personal jurisdiction, please give it a like. If you haven't subscribed already, you should. You can just hit the subscribe button. Why not? And did you know for a mere 99 cents, you too can help support the channel? It's true. You can become a member. Also, there's a link that should be being announced periodically by my bot that says how you can donate through StreamYards, Streamlabs, if you're into that kind of thing. So yeah, all that good stuff. So please do all those please do all the YouTube-y things. Until later, my friends, I hope all's well. Cheers. Good night.